Hello everyone, a warm good morning to all of you. Would like to welcome. So, how are everyone? I hope all you are good. So, as you know, we are in a continuation of Indian polity, and in this session, we'll discuss the important constitutional amendment and judicial judgment. It is a very demanded topic. It has been requested to me that sir, please make the video on it. Now the day is come, and we are with the important constitutional amendment and judicial judgment. So, as you know that in our examination different questions has been come with respect to this topic, be it your the 86 amendment or be it your 61 amendment, and there are the lot of things which has been changed in current times, and we will discuss that the different amendment, how it's important in present circumstance, and how the question can frame in our examination. So guys, on this note, would like to start. First we will discuss few of the previous question, that we will try to know that how the question basically they ask. I am going to quickly demonstrate this question. You have already gone through this question, so you can see these questions was asked in your 2023 December SSB. The question is about 86 amendment, 96 amendment, okay, and the 102 amendment. So there are different constitutional amendment act, and with respect to that they ask the question. That is how one kind of sample type questions. Then you can also see the 821 constitutional amendment act. Direct they can ask the question, or the statement based question, as you basically seen here. Like you can see here also the different cases like basic structure, okay, then also the related to the article 21. So we can say that this kind of question can be there. That one thing is that the judicial cases like Kesavanand Bharati case, Minora Mill case, SR Bommai case, then SR Bommai case. So these cases along with the constitutional amendment can be asked in our examinations. Then like for ninth schedule, okay, is what to the constitution was inserted by which amendment? So first amendment. So these are how the different constitutional amendment act, how the different amendment act lead the different regulation rules, or added the different schedule in our constitution. So these are how the your previous question, and we basically analyze that we need to focus two things, that your constitutional amendment along with the judicial cases. So on this note, would like to start our discussion, but there is a sample question before you that it's new uh, for all of us. So you can attend this question. That is how the match of the following, and your time start now. So this side is basically constitutional amendment, and this side the provision, okay. So constitutional amendment is like 31, 100, 61 and 106. This side is the provision like 33, reservation to women and central legislatures, change the Lok Sabha seat from the 525 to 545, and reducing the voting age from age 21 to 18, and land boundary agreement. So this is how you need to match the different amendment and the provisions. So guys, your time is off, so let's match. So 31st amendment change the Lok Sabha seat from the 525 to 545, okay, and the 100 constitutional amendment act, the land boundary agreement, okay. So your answer is basically option A. You can easily match, okay. Answer of this question option A. So this is how it is a sample question, and on this question we'll try to cover the important constitutional amendment act, as you can notice here, and the related provisions, okay. Guys, are you excited to learn about the constitutional amendment act and judicial cases? Then quickly, why not you like my channels, okay? Quickly like the channel, and also quickly share with your friend, okay. Please share with your friend, okay. And on this note, let's start. Here there is a constitutional amendment and Supreme Court judgment, okay. So this is going to be a beautiful presentation before you, where we are going to cover all the amendment related to our examination, okay. So guys, let's start. So first constitutional amendment act. So first Constitutional Amendment Act, Parliament can amend the fundamental rights. Okay, so it declares that fundamental right can be amended by the Parliament. And first Constitutional Amendment Act deal with land reform. Okay, land reform, okay, and also it include the 9th schedule in the constitutions. Okay, so like there is a questions that 9th schedule was the inserted by which amendment? It is the first amendment. Okay, so here two things you need to remember: first amendment, 9th schedule, and the basically the parliament can amend the fundamental rights. And subsequently Shankari Prasad case also support that thing. Yes, the parliament have a power to amendment the fundamental rights. Okay, so that is how the two questions you get here. Moving to the next, 7th Constitutional Amendment Act 1956 that abolished the fourfold state system. That is how in way before your the independence, there is a fourfold state system, that is the state A, state B, state C, state D, and it abolished that system and create the state reorganization on basis of language. Okay, that is how 1956, as we all know, state reorganization on basis of language. And also 7th Constitutional Amendment Act that one high court for the 2 or more states. Okay, so in which amendment it declared that one high court for the 2 or more states? It is 7th Constitutional Amendment Act. Similarly, a person can be a governor for 2 or more state or union territory under the 7th Constitutional Amendment Act. So two things you have to notice, that the one high court for 2 or more states, or a person can be a governor for 2 or more states under the 7th Constitutional Amendment Act 1956. Okay, it's important. So they can ask the question either match of the following or the incorrect or correct pairs. Then moving to the 9th Constitutional Amendment Act 1960. So through the amendment, the parliament can give its territory to any foreign states and also related to the very union quest. Okay, so 9th Amendment, Constitutional Amendment Act 1960 that talks about the parliament has a power by amending the constitution can give any foreign territory to the foreign nations or foreign territory. Okay, and it is also supported by very union case. Okay, getting my point? So the question arises, why this thing is important? Because right now there is a trend. Okay, there is a trend in news, that is how the Kachavhetu Iceland to the Sri Lanka. So the Kachavhetu Iceland to Sri Lanka, it's a trendy topic, and they can ask related to anything, that they can simply ask the question under which amendment the parliament has the power to give any territory to the foreign nations. Okay, then moving to the next, Goloknath versus State of Punjab, as we have discussed, and Goloknath versus State of Punjab, as a response to the first amendment act, it declared that parliament cannot amend the fundamental rights. Okay, as we have studied, in first amendment the parliament declared that fundamental right can be amended, okay, by the article 368, but Goloknath case versus State of Punjab 1967 declared that the parliament cannot amend the fundamental rights. So two things you need to remember, what is for Goloknath case and what is for the Shankari Prasad case, or say for example first amendment act. Then moving to the next, a 24th Constitutional Amendment Act 1971, in response to the Goloknath case, the parliament can amend the fundamental right and the president is bound to give his assent to the constitutional amendment bill. Okay, so here 1971, okay, 24th Constitutional Amendment Act 1971, during that time who is the prime minister? Indira Gandhi is the prime minister. Okay, so we need to go to the historical background, then you can easily remember these facts, because this is all the factual information, and for that you have a need to understand the circumstance of that period of time. Okay, so Goloknath case 1967 declared that parliament cannot amend the fundamental rights during the Indira Gandhi government, and you know the Indira Gandhi is the type of leader. In 1971 he basically go against the Supreme Court judgment and declare that parliament can amend the fundamental right. Not only that, she also makes sure that the president is bound to give assent to the constitutional amendment bill. Okay, so that is how the two things, that you can see how the executive can go against the Supreme Court judgment. Okay, that was the scenario we have been also noticed in our Indian political systems. Okay, then moving to the next, a 27 Constitutional Amendment Act related to the State Legislative Assembly. Okay, so Manipur, we know all know. So in 1970s, you need to check the year. Okay, so 27 Constitutional Amendment Act to the State Legislative Assembly Manipur. Why it is important? Because there has been a like conflict since 1 year in Manipur, so that's why it became very important that you have to remember just 27 Constitutional Amendment Act related to the Manipur. Then moving to the next, the very legendary case, that is our Kesanand Bharati case versus Kerala, 1973. It was against your basically the 24 Constitutional Amendment Act 71 that Parliament can amend the fundamental rights. It against to that, and Kesanand Bharati case highlighted that yes, Parliament can amend the fundamental right, but it should not or it cannot amend the basic structure. Okay, so Kesanand Bharati case clearly mentioned that yes, Parliament can amend it the fundamental right, but it should not amend or should not violate the basic structure of the constitution. Okay, so that is how you need to remember. Then moving to the next, that at the 31 Constitutional Amendment Act 1973. So 31 Constitutional Amendment 1973 basically changed the Lok Sabha seat from 545 to 545. Okay, 525 to 545. Okay, so change the Lok Sabha seat from 525 to 545. So it's very important, because if you have seen the questions in Odisha politics and government unity, they have already asked the question that in which year the legislative assembly for the Odisha became 147 seats. Okay, we all know during the time of the Nandini Satpathy government. So similarly they can ask the question, this the very common thing, because it's genuine that obviously anything can be asked, because this year is going to be or is under the Lok Sabha election. Okay, so that is how it's important, that 31st Constitutional Amendment Act you need to remember. Then 39 Constitutional Amendment Act 1975, after the Allahabad High Court. Okay, after the Allahabad High Court verdict, okay, that declared that the Indira Gandhi government's general Lok Sabha election is null and void. Okay, so Allahabad High Court declared in 1975 that Indira Gandhi's election to the Lok Sabha is null and void. Okay, so basically null and void, then the post can be abolitionary as a PM. So in that scenario, what the basically Indira Gandhi government or Congress government do that time, that president or vice president and speaker are beyond the judicial review. So it is also against go the judgment that the judiciary cannot review the matter related to the president, vice president, prime minister and speakers. Okay, so to basically protect her authority, she has been made a number of articles with respect to that. Okay, with respect to that, and you can remember also here that time also the national emergency declared when the Allahabad High Court declares the elections of the Indira Gandhi null and void. So that's why the reason basically the national emergency declared, and that time the 39 Constitutional Amendment Act implemented, in which it declared that the president, vice president, prime minister matter cannot be challenged in the court of law. So that kind of tendency you can find that time. Okay, so this is how in that story manner you can understand or remember the concept. Then guys, 42nd Constitutional Amendment Act during the emergency only. Okay, during the emergency only, known as mini constitution, a lot of thing has changed in that time. That the three word we all know, that basically added in preamble, that is socialist, secular, integrity. Okay, and also the administrative tribunal was created in 42nd. So they can confuse you. So administrative tribunal was created in which amendment? So it is 42nd. Okay, then the president is bound by the advice of the cabinet. Okay, because president is bound by the advice of the cabinet. That time the national emergency are declared, and Indira Gandhi government said that it's the president who declared the national emergency, and by the time she make an amendment that president is bound to advice of your cabinet. So this is how you can remember how the system or political decay was there that time, because lot of thing was against the Supreme Court judgment and it is violate the different things. Okay, so this is how you need to remember. Then moving to the next, Minora Mill case, and you can see the tendency here, like first the Shankari Prasad case, then again the Supreme Court challenged that and Golanath case, and to challenge the Supreme Court again the Parliament came with another amendment, and again the Parliament came with the Supreme Court also came with the Kesanand Bharati case. Then after the 42nd amendment, again your the basically Mineral Mill case basically came to picture 1980 after the abolition of emergency. And they talks about, in response to the 42nd Amendment Act, a basic structure doctrine include the supremacy of the Constitution and rule of law. You cannot violate the supremacy of the Constitution. You cannot go against the rule of law. After the emergency in the Mineral Mill case 1980, it was provided by a verdict by the Supreme Court. Okay, it's clear. Then moving to the 44th Constitutional Amendment Act 1978. After the 42nd, the 44th Constitutional Amendment Act 1978 came to picture, and that time who is the Prime Minister? Morarji Desai Janata government. Okay, Morarji Desai Janata government, as you all know, as a critique to the Congress government, after the emergency there was a election, and after that Morarji government led by the basically Janata government, Janata party government came to picture, and they try to change the basically the rule and regulation in our constitutions, which was basically done by the previous Prime Minister, that is Indira Gandhi government. What are did they change? Now they changed the word internal disturbance to the armed rebellion in case of impose of the emergency. Okay, as you all know, the national emergency in 1970s was declared in the view of like internal disturbance. Okay, but here the 42nd Constitutional Amendment highlight that you cannot declare a national emergency due to the internal disturbance, but you can declare due to the armed rebellion, until unless the people are go against or kill the government, you cannot declare the emergency. Okay, so that is clearly mentioned, the internal disturbance is not a ground for the national emergency. Okay, internal disturbance means what? If something is not appropriately function in the nation or the states, that is how internal disturbance. But this is not a appropriate cause according to the 44th Constitutional Amendment Act to declare an emergency. So that is how clearly they highlighted. And they also highlighted that the Morarji Desai government, that Article 20 and 21 will not abolish the during national emergency. So during the national emergency, you cannot abolish the Article 21, the right to life or liberty of the people, or you cannot abolish the Article 20 which deal with the protection against arrest and detention. You cannot arrest anyone without any reason or any things. Okay, because that time a lot of innocent people went to the jail without any cause. So that is how the 44th Constitutional Amendment Act 1978 and came to picture. So that is how the things you can remember, how the tussle between the different political party and government and the Supreme Court. Okay, so it is quite interesting, but it's very problematic was that time, because there was, if that time was not came out of the national emergency, we are not enjoying this kind of freedom and right, even if I cannot make the video. Okay, because that time was very problematic for the urge. Okay, and a lot of thing also good has been done, but there is also significantly threat to democracy we have been observed that time. Okay, then moving to the next, the 52nd Constitutional Amendment Act 1985, the anti-defection law and 10th schedule included in the constitution. So here spelling mistake, just try to correct it. So 10th schedule added in the constitution under the 52nd Constitutional Amendment Act, which deals with the anti-defection law, that a disqualification of a member of the parliament and legislative assembly in case of anti-defection law. Okay, so that the member of parliament and state legislative assembly, without the permission of the political party from where they basically elected, they cannot change or they cannot go against the political party decision. And it is very important, this 52nd Constitutional Amendment Act 1985, because in recent 2024, if you are in a trend of watching the news or studying the newspaper, you can remember in Himachal Pradesh the 3 MLA has been suspended by the Congress government because they vote against the Congress government during the time of Rajya Sabha vote. So that's why the 52nd Constitutional Amendment Act it became very important. So you can see this kind of thing in your questions. So moving to the next, the 61 Constitutional Amendment Act, the 1989, and it is the very obviously it is important because reducing the voting age from 21 to 18, that is how 61 Constitutional Amendment Act. And there is a question for you guys, and it's very like obvious question, that right to vote is a legal or constitutional rights. So this is your we can say that not a homework, but it is also your duty that to know about right to vote is a legal or constitutional right, because there is a lot of confusion with respect to that. Even if I am not able to reach a conclusion that whether right to vote is a legal and constitutional rights, I want to know from your side that how you understand it's a legal right or constitutional right, or what your opinions. Okay, so hope you will come to me or reach to me with this solution of the right to vote as a constitutional or legal right. Okay, so moving to the next thing, that is how SR Bommai case 1994 of federalism and secularism as a basic structure of Indian constitution. So in SR Bommai case 1994, the federalism and secularism declared as a basic structure of the Indian constitution. So, okay, do remember that thing. Then 86 Constitutional Amendment Act 2002, all time favorite and multiple time has been asked examination, that Article 21, the free and fair the free and compulsory education for the children from the age 6 to 14 years. Okay, so Article 21 deals with what? The free and compulsory education for children from age 6 to 14 years, and it also changes the subject matter of the Article 45, early childhood care up to the age 40, up to the age 6. Okay, so do remember that thing, Article 21 under the 86 Constitutional Amendment Act, that a free and compulsory education for the children from 6 to 14 years. Similarly, so here also the change in DPSP Article 86 CA also brought change in DPSP, that the 45 Article 45 deals with what? The early childhood care up to the age 6 years. Okay, up to the 6 years. Then it also make change subsequently in fundamental right, that 11th fundamental duties. Okay, so 86 CA added the 11th fundamental duty in your fundamental duty, that deals with the every citizens, every parents have to basically give their children the education from the 6 to 14 years. So it is a fundamental right of every citizen or every parents of that India to provide the education, the compulsory education from 6 to 14 years. Okay, so that is how the very important thing, 86 2002. Okay, then moving to the next, that is how the 96 Constitutional Amendment Act 2011 changed the word Oriya to the Odia in 8th schedule, that is how official language. Okay, so Odia is official language in Odisha, we all know, and it has been changed from the word Oriya to Odia in 96 Constitutional Amendment Act. So it is important because we cannot forget that thing, it's very important. Then moving to the next, 99 Constitutional Amendment Act 2014, the introduction of the National Judicial Appointment Commission. Okay, so 99 Constitutional Amendment Act introduced the National Judicial Appointment Commission. What does it mean? That National Judicial Appointment Commission go against the collegium system. As we all know, collegium system for the appointment of the Supreme Court, judge of the Supreme Court and High Court, and it consists with the basically the judges of the Supreme Court. Okay, judges of the Supreme Court. But in 2014, under this amendment, 9 amendment, it basically introduced the National Judicial Appointment Commission, which consists with your law minister and eminent jurist. Okay, but however, it was declared null and void by Supreme Court on 16 October 2015. Okay, so on 16 October 2015, Supreme Court declared National Judicial Appointment of the National Judicial Appointment Commission, it's a problematic for the independence of the judiciary. So that's why it's no longer came to existence. Okay, but still it's a part of the constitution under Article 124A. But do remember, it's became null and void after the declaration of the Supreme Court judgment. This is how the important 99 Constitutional Amendment Act. Then moving to the next, the 100 Constitutional Amendment Act 2014, under the 1974 Land Boundary Agreement, some territory was given to the Bangladesh. Okay, so in the government of Modi government, so 2014 under 100 Constitutional Amendment Act, some territory has been given to the basically Bangladesh under the land boundary agreement. Okay, so that's why I have asked I was asked to you this question, that is how 100 Constitutional Amendment Act, the land boundary agreement. Okay, why it is important? Because I have already said to you multiple times, because Kachavadu Islands issue to the Sri Lanka. Okay, so that is how it's important, and they can ask the question with respect to that. Then 102 Constitutional Amendment Act 2018, that article 333, my mistake guys, it's article 338. Okay, article 338b. Okay, article 338b, that talks about National Council of Backward Commission, which was created, can anyone tell me, 1993, and it was became a basically constitutional body under the 338. Okay, so 338. Okay, B, Constitutional Amendment Act 102. So do remember that thing, the 338 and Constitutional Amendment Act 2018. Okay, 338. Okay, so this is how the important thing, because it has been asked multiple time in your examination. Then 103 CA, that is how 10% reservation for EWS for the admission in government and the private institution as well as the job sector also. That is how 103 Constitutional Amendment Act 2019. Okay, it's also important because for the first time EWS also, the people those are from general, they are also getting the reservation in our the educational institution, private institution. Okay, so that is how the things. Then moving to the last, not the least, and it's very historical and the landmark amendment, that is how 106 CA 2023. Okay, that talks about the 33 reservation for women in Lok Sabha and State Legislative Assembly. But however, it was not in effect, because after the census it will be effect. Okay, but during the, if you ask me, during the this term of Lok Sabha or the general election of State Legislative Assembly election, it was no longer in effect. That you need to remember, but it will be implemented after the census. Okay, so 106 CA 2023, the 33% reservation for women in where Lok Sabha and State Legislative Assembly. So they can confuse you that also in Rajya Sabha, but it's not Rajya Sabha, it's Lok Sabha and the State Legislative Assembly. So that's, you need to be clear in your mind. Okay, so as you know that 33% reservation is also provide in the Panchayat also. Okay, Panchayat, the 33% reservation for the what, women, that is how 1/3 reservation, we all know. Okay, so but the thing is that you need to provide the answer that under which article a 33% reservation is provided to the women in the Panchayat Raj institutions. I hope you will provide the answer. Okay, so guys, on this note, with this note, I would basically come to the end point of our lecture, that we have discussed all the Constitutional Amendment Act with respect to your SSB and PGT examination. I can assure to you from this table the question will be asked with regard to the Constitutional Amendment, and you will definitely get benefit in your examination. On this note, I would like to end here, but I need one thing to seek your attention, that if you like my effort, please subscribe our channel, and if you really want to bring such kind of content for you, you need to share with your colleagues, and to also like our channel as your mark of attendance, because this kind of thing motivate us. So on this note, would like to stay here. Thank you everyone for being part of these lessons.